The war ended without ending the question of loyalty. Between May 1945 and the close of 1947, governments that replaced occupation regimes, both Allied military administrations and restored national authorities, built legal and administrative systems to determine who had collaborated, who had merely adapted to occupation, and who had resisted. These systems did not start from a blank slate. They drew on pre-war legal codes about treason and emergency powers enacted during 1939 to 1940, wartime decrees issued by governments in exile, and Allied commitments negotiated at Tehran, 1943, Yalta, February 1945, and Potsdam, July-August 1945. The declared goals overlapped: to remove from power persons considered dangerous to public order, to punish crimes committed under occupation, to re-staff state and economic institutions, and to stabilize post-war societies that had been reordered by requisitions, forced labor, deportations, and black market survival economies. Definitions mattered from the first day of liberation or capitulation. Collaboration could mean organized political cooperation with the occupier, economic service through contracts and deliveries, participation in security forces, or acts of denunciation that led to arrests. Yet, in many jurisdictions, legal guilt required a specific act defined in law, providing enemy intelligence, joining a prescribed formation, commanding police units implicated in unlawful violence, or signing contracts that materially strengthened the enemy's military effort. Administrative vetting widened the aperture. People could be removed from a post or barred from employment without a criminal conviction if a commission classified them as politically unreliable. The dual track, criminal prosecution versus administrative screening, created different thresholds of evidence, procedures, and outcomes, and it shaped who would carry a stigma and who would return quietly to work. Allied occupation authorities set the initial parameters in Germany, Austria, and Italy. In the western zones of Germany, the Allied Control Council issued denazification directives that required questionnaires, personnel files, and hearings before classification boards. Categories separated major offenders, activists, fellow travelers, and exonerated persons. The same framework was applied to teachers, judges, industrial managers, municipal officials, and journalists, as to guards or party functionaries, but penalties differed. Imprisonment or asset seizure for some, dismissal, pension reductions, or professional bans for others. In the Soviet zone, Soviet military administration orders and land reform decrees combined with the reorganization of police and courts to remove former National Socialist cadres and to place anti-fascist committees and newly formed political parties in key positions. Across zones, a practical constraint cut through doctrine. Factories, schools, and utilities required trained personnel. The need to restore services limited how far purges could proceed without disrupting food supply, transport, or public safety. Restored governments across Western and Northern Europe launched their own legal purges under national sovereignty. In France, the provisional government replaced ad hoc retribution with a legal purge through special courts and professional committees, guided by ordinances drafted in Algiers and London during 1943 to 1944. The Netherlands created bijzondere rechtspleging, special jurisdiction, to try political collaboration, and instituted administrative tribunals to vet civil servants, police, and journalists. Norway conducted the Landsvik-oppgjøret, treason settlement, combining criminal trials for political and security collaboration with wide use of fines and loss of rights. Belgium reactivated emergency legislation and convened military courts for wartime offenses, while administrative commissions inspected employers and local administrations. The variation lay not only in statutes but in the political coalitions implementing them. Resistance movements, exile politicians, and pre-war parties all sought to define a legitimate post-war state, and the purge became an instrument of that definition. In Central and Eastern Europe, retribution intertwined with state transformation. In Poland, a sequence of decrees issued by the Polish Committee of National Liberation from July 1944 targeted crimes against the state and unlawful collaboration, while also institutionalizing verification and repolonization in territories shifted westward after the war. Czechoslovakia's retribution decrees established extraordinary people's courts. Parallel administrative measures removed Germans and Hungarians from citizenship, subject to exceptions for documented anti-fascist conduct. And professional commissions examined the wartime behavior of officials, educators, and artists. In Yugoslavia, the AVNOJ decisions and people's courts prosecuted wartime killings, forced labor, and collaboration with occupation authorities, as partisan structures became state structures. Throughout this region, the presence of Soviet forces and liaison officers shaped priorities. Screening emphasized security, control of communication and transport nodes, and the replacement of hostile networks in the police and administration. Soviet repatriation and filtration added another layer. Millions of former prisoners of war, Ostarbeiter, and displaced civilians moved east through transit points and NKVD filtration camps, where commissions sorted returnees into categories: cleared for immediate release, assigned to labor battalions, retained for further investigation, or transferred to security organs for prosecution. The stated rationale was to distinguish forced compliance from voluntary aid to the enemy and to identify those who had served in enemy formations, such as Schutzmannschaften or auxiliary police. The process also served manpower and security needs, labor shortages and reconstruction, and the restaffing of local Soviets, factories, and railways. As in Western screening, evidence could be testimonial, documentary, or inferred from unit assignment, and individual outcomes depended on the composition of commissions and the urgency of local economic demands. Across all theaters, the politics of memory formed in parallel with legal and administrative action. Governments promoted narratives that emphasized resistance to legitimize the new order, honored specific units or movements, and separated national from anti-national conduct. These narratives influenced which cases prosecutors prioritized and which offenses commissions considered disqualifying. A newspaper editor who printed occupation orders might be treated differently from a factory director who fulfilled military contracts, depending on whether the post-war coalition relied on the press or on industrial output for stabilization. Communities faced their own tensions. Denunciations lodged under occupation reappeared as evidence. Personal rivalries resurfaced in testimony, and local authorities weighed purity against continuity when deciding whether a school could open or a tram line could run. International law provided a separate but intersecting track. War crimes trials at Nuremberg, in national courts, and before military tribunals targeted planning and execution of aggressive war, crimes against humanity, and violations of the laws of war. These trials established records, but they rarely resolved the mass of everyday collaboration cases that stayed within domestic jurisdictions. Still, the documentary archives produced for international proceedings, occupation decrees, transport lists, police reports, filtered back into national purges and vetting, enabling investigators to connect individual conduct to institutional patterns. Public sentiment did not map neatly onto legal categories. Populations expected removal of notorious figures and some measure of accountability, yet they also demanded rapid normalization, wage payments, rationing, reopened schools, and functioning courts. The tension between exemplary punishment and pragmatic reconstruction framed the first decisions in 1945 to 1947. In that frame, who became a collaborator depended on how law, administration, and memory, as well as immediate needs for skilled labor and political stability, combined in each jurisdiction. The next phase would translate these premises into specific opening moves, arrests, questionnaires, personnel files, and the first lists of persons barred from public service. Liberations and capitulations translated into procedures within weeks. In Germany and Austria, Allied military government ordinances issued in May, June 1945 created registration and control mechanisms for former party members, security personnel, and key professionals. In the American zone, standardized questionnaires required personal histories, party affiliations, and details of wartime employment. Local Sprüchkammern, denazification tribunals, were formed with mixed panels under military supervision to begin classifying respondents. British and French zone directives paralleled this approach, but delegated more discretion to regional administrators and professional bodies. In the Soviet zone, the Soviet military administration established commissions within provincial governments and police to identify party cadres and to reorganize municipal authorities. Everywhere, the first operational step was the same: assemble lists, secure archives, and freeze personnel decisions pending review. Restored governments initiated legal and administrative purges as soon as ministries resumed control. In France, ordinances drafted in 1943 to 1944 came into force after the provisional government installed prefects and reactivated courts. Cours de justice opened files on major political and security collaboration. Chambres civiques examined loss of civic rights under the category of national unworthiness. The Netherlands implemented the Besluit buitengewoon strafrecht, authorizing special courts for wartime offenses, and establishing political screening of civil servants, journalists, and teachers. Belgium instructed military courts to try security-related crimes and convened commissions to vet municipal employees and industrial managers. Norway's treason settlement began with police arrests of members of Quisling's party, followed by prosecutors' circulars defining evidence standards for political cooperation and service in occupation forces. The common pattern combined criminal dockets for defined acts with broader professional inspections to determine who could continue in office. In Central and Eastern Europe, opening moves overlapped with territorial and institutional change. The Polish Committee of National Liberation issued decrees in mid-1944 and 1945 establishing special criminal courts and providing for administrative verification in formerly German-held regions. Czechoslovakia reconstituted state power through retribution, decrees that created extraordinary people's courts. Separate commissions reviewed citizenship status and professional eligibility. In Yugoslavia, people's courts convened under AVN Mugier decisions, while local committees, built out of wartime partisan structures, assumed control of police, transport, and food distribution. Because these states were rebuilding while absorbing displaced populations and new borders, early screenings prioritized positions tied to public order, rail operations, and provisioning. Repatriation and filtration added an immediate security dimension. Allied liaison offices coordinated with Soviet, American, British, and French commands to process prisoners of war and civilian deportees. In the East, NKVD and military counterintelligence units ran filtration points where returnees were interviewed, their unit histories cross-checked, and their future assignments determined. Individuals were released, placed in labor battalions, or held for additional investigation based on documentation and testimony. In the West, displaced persons camps maintained by military authorities and international agencies compiled identity lists and reported suspected war criminals or collaborators to national prosecutors. These parallel streams, domestic purges and cross-border repatriations, fed each other through exchanged arrest warrants, personnel cards, and captured records. Command structures reflected layered authority. Allied theater commands issued framework directives. National ministries of justice and interior translated them into regulations. Regional prefectures or land governments created implementing commissions. Police and gendarmerie executed warrants. Professional chambers audited their members. In Germany, Allied Control Council directives standardized key categories and authorized property seizures in specified cases. In Austria, a provisional government worked under occupation oversight to pass laws on the removal of National Socialist influence. In Italy, royal and republican authorities, alternating under armistice conditions and then post-1946 institutions, combined purge measures with the reappointment of administrators needed for municipal services. Coordination meetings between military government officers and local officials focused on practical targets, reopening schools, restarting tram lines, and staffing water and power utilities, while suspending individuals pending review. Evidence collection began with what was immediately available: police registries, occupation-era personnel rosters, requisition ledgers, and permit files were secured and indexed. Resistance archives, exile government records, and Allied intelligence reports were folded into case files. Witness deposition forms were standardized to record dates, locations, and named units. Where occupation authorities had kept thorough files, such as employment records for auxiliary police or factory contract registers, investigators cross-referenced names with post-war applications for work or ration cards. In areas where records had been destroyed or evacuated, commissions relied on municipal rolls and neighborhood committees to identify former office holders and to confirm residents' histories. Arrests and suspensions followed priority lists. Security services and political police were addressed first. Schutzpolizei and gendarmerie cadres in former German-held regions. Auxiliary police units in Eastern Europe. Vichy-era intelligence and militia staff in France. Political party organizers who had worked openly with occupiers in the Low Countries and Norway. Next came editors of occupation-controlled newspapers, directors of broadcasting, and heads of state companies or large private firms that had supplied occupation authorities. Educational and cultural sectors were screened through professional committees that examined public statements, memberships, and institutional collaboration agreements signed under occupation. The first months exposed immediate constraints. Courts and commissions received more files than they could process. Prosecutors triaged by focusing on cases with documentary corroboration or those involving command responsibility. Administrators negotiated with line ministries to authorize provisional reinstatements in essential services, subject to ongoing investigations. In ports and industrial zones, shortages of engineers, locomotive drivers, and foremen forced exceptions with temporary clearances and reporting requirements. These operational decisions did not resolve questions of culpability. They deferred them to later hearings while preventing disruption of rationing, transport, and public health. Public communication formed part of the opening phase. Governments announced that retribution would proceed under law, published the legal basis for arrests and suspensions, and identified the institutions responsible for receiving complaints and evidence. Notices specified that denunciations required dates, places, and names of witnesses. Allied commands issued bulletins on the scope of occupation authority and the rights of persons under investigation. This messaging aimed to channel private grievances into formal processes and to separate personal disputes from legally defined offenses. By the end of the initial phase, roughly from mid-1945 into early 1946, depending on the country, the machinery was in place, legal statutes enacted or reactivated, commissions seated, evidentiary standards drafted, and essential services staffed under provisional clearances. The next stage would move from intake to classification, assigning categories, issuing bans and sentences, restoring individuals to posts, or referring cases to higher courts, and would begin to show how differing priorities and capacities produce divergent national outcomes under the common objective of stabilizing post-war society while defining the boundaries of acceptable conduct under occupation. Planning began from first principles, what counted as punishable conduct, who would judge it, how evidence would be gathered, and how far the purge could proceed without halting recovery. Governments and occupation authorities framed objectives along three axes. Security required removing those deemed likely to subvert police, railways, communications, or municipal administrations. Legitimacy required visible accountability through courts and transparent procedures. Continuity required keeping power plants, mines, ports, schools, and hospitals functioning. Policy papers in 1945 to 1946 expressed these priorities in legal and administrative instruments. In Germany, Allied Control Council Law Number 10/20 December 1945 set the basis for prosecuting major crimes. Directive Number 24 12th of January 1946 and Directive Number 38 12th of October 1946 guided the removal and classification of former National Socialists. In France, ordinances dating from August 26, 1944, created national unworthiness as a civil category distinct from criminal treason. Czechoslovakia's Retribution Decree Number 16/1945 Collaborator established extraordinary people's courts. Decree number 33/1945 addressed citizenship in connection with wartime conduct. Poland's decree of 31st August 1944 defined crimes against the nation, while Yugoslav Avnoje decisions structured people's courts and property seizures. Norway's settlement drew on penal code treason articles supplemented by London-based decrees. The Netherlands used besluit, buitengewoon, strafrecht, drafted in exile, and special jurisdictions for political offenses. Operational planning translated statutes into workflows. Ministries of justice drafted evidentiary rules, requiring dated documents, unit designations, and named witnesses. So, commissions could triage files quickly. Interior ministries mapped critical posts, whose suspension could imperil services. Locomotive engineers, dispatchers, power station foremen, waterworks supervisors, senior nurses, and school principals. Schedules set, review, waves. Security services and police first. Broadcasting and major press. Second, large industrial managers third. Education and culture through professional committees in parallel. Registries from occupation years, identity cards, labor office ledgers, requisition lists, auxiliary police payrolls were secured, indexed, and cross-checked against post-war employment applications and ration rolls. Where records were incomplete, planners instructed local committees to corroborate claims by residents' histories and service in named units. Classification doctrine shaped case handling. Some systems emphasized individual culpability tied to specific acts, membership in prohibited formations, participation in unlawful arrests, contracts for military deliveries to the occupier, while others added political reliability as an administrative standard. German denazification boards in the Western zones adopted 5 categories ranging from major offenders to exonerated, with differentiated sanctions: imprisonment, asset sequestration, professional bans, fines, or warnings. French procedures separated criminal treason before Cour de justice from loss of civic rights before chambres civiques, allowing a gradation of penalties. In the Soviet zone, and later in Eastern European states aligning with it, screening combined security vetting with party state staffing, giving weight to anti-fascist credentials and post-war political affiliation alongside wartime records. Planners thus built systems able to remove, reassign, or rehabilitate depending on the category and local labor needs. Resource planning confronted volume. Authorities anticipated large inflows of questionnaires and denunciations immediately after liberation. To manage this, they standardized forms with fields for dates, employers, unit numbers, and locations, and they instructed police to reject unsigned or undated accusations. Specialized units handled captured archives. In Germany, document centers cataloged party and SS personnel files. In France and Belgium, inspectors consolidated press and broadcasting records. In Poland and Czechoslovakia, offices processed German and Hungarian language files alongside local documents. Training sessions briefed commissioners on chain of custody rules, the difference between command responsibility and individual execution of orders, and how to weigh compulsion versus voluntary action. Intelligence estimates informed priorities. Allied and national security services assessed which organizations posed ongoing risks: former political police, auxiliary gendarmeries, security battalions, informant networks, and collaborationist militias. Reports recommended early detention of command staff and document custodians to preserve evidence. Border districts and transport hubs received special attention because smuggling and population movement could hide fugitives or facilitate document destruction. Repatriation flows were integrated into planning. Liaison officers at prisoner of war assembly centers and displaced persons camps collected service histories and relayed suspect names to national prosecutors. In the East, NKVD filtration commissions categorized returnees for release, labor, or further inquiry, with instructions to flag former personnel of Schutzmannschaften or occupation administrations. Miscalculations and constraints appeared in draft timetables. Early estimates underestimated the number of files per suspect once attachments. Letters, payroll pages, and requisition forms were included. Backlogs forced triage rules. Give precedence to cases with documentary corroboration or with allegations of violence. Defer borderline economic cases pending audits. Shortages of legal professionals required recruiting assistant assessors from universities and bar associations. In rural districts, mayors and teachers were temporarily seconded to commissions, creating potential conflicts of interest that planners attempted to mitigate by rotating panels and publishing recusals. Propaganda and public information were planned as management tools rather than as verdicts. Governments prepared communiques explaining that purges would proceed under law, listing responsible offices and appeal routes, and cautioning against unauthorized reprisals. Resistance movements and veteran groups were briefed to channel evidence through formal deposit points rather than through public demonstrations. Occupation authorities issued multilingual notices outlining rights during questioning and the consequences of destroying records. Radio segments described how questionnaires would be used and how long provisional suspensions might last, seeking to balance expectations of swift justice with the reality of stage processing. Logistics resembled a supply chain. Intake centers collected questionnaires and deposits. Sorting offices batched cases by sector. Investigators assembled files. Boards rendered initial classifications. Appeal bodies reviewed sanctions. Labor offices executed reassignments or reinstatements. Metrics tracked throughput. Average days from intake to first decision. Share of cases with documentary evidence. Reinstatement rates in essential services, and proportion escalated to criminal courts. Where numbers rose beyond capacity, planners authorized summary review for low-risk categories based on clear exculpatory records, reserving full hearings for contested or high-responsibility cases. Comparative planning diverged with political calendars. In Italy, the institutional transition, culminating in the 2nd of June, 1946, referendum intersected with purge measures and the amnesty of 22nd of June, 1946, forcing ministries to integrate rehabilitation pathways earlier than in states without imminent constitutional change. In Austria, coalition agreements under occupation supervision balanced removal of National Socialist influence with rapid restoration of federal administration. In Denmark and Norway, small administrative corps enabled tighter file control but limited surge capacity. In France and Belgium, larger bureaucracies allowed broader screening but produced heavier backlogs. In Poland, Yugoslavia, and Czechoslovakia, land reform, population transfers, and the restructuring of security organs meant that staffing targets for police, judiciary, and railways were integral to purge planning, not an afterthought. By late 1945 and into 1946, the planning phase yielded operational calendars, category definitions, and evidentiary protocols. What remained was to move from design to execution at scale, the first mass classifications, the issuance of bans, property measures, and sentences, and the simultaneous reinstatement of personnel whose files showed either constrained compliance or verified opposition to occupation. The next stage would reveal how these plans fared under pressure when early hearings confronted contested testimony, missing archives, and the competing demands of justice, deterrence, and reconstruction. The first hearings translated design into action. In France, the High Court convened to try Philippe Pétain in Paris from 23 July to 15 August 1945. The court imposed a death sentence on 15 August, immediately commuted to life imprisonment by the head of government. The trial of Pierre Laval opened on October 4, 1945, before the same jurisdiction. After adjournments and a failed appeal to the Court of Cassation, the sentence was carried out on October 15, 1945. Parallel Cour de Justice began processing files transferred from the Paris and provincial parquets, while Chambres civiques issued decisions on national unworthiness, removing electoral rights and access to public office for specified periods. These opening cases established rules of evidence, dated signatures on decrees, cabinet minutes, and correspondence with occupation authorities, and illustrated how criminal conviction and civil degradation operated on separate tracks. In Norway, the Landsviksoppgjøret entered its visible phase with the arrest and charge of Vidkun Quisling in May 1945, the indictment filed in August, and proceedings before the Oslo lagmannsrett from 8 September to 10 October 1945. The court applied pre-war treason articles supplemented by exile decrees and weighed organizational leadership, orders to police, and cooperation with German security organs. The Supreme Court reviewed legal issues on expedited schedules to keep lower court procedures aligned with statutory bases. Early judgments against senior national Samling figures signaled that political leadership and command responsibility would receive priority in the first tranche of cases, while district courts addressed service in auxiliary formations and local administrations. The Netherlands moved from arrests and internments to formal charges as the Bijzondere Gerechtshoven, special courts of justice, commenced sittings in late 1945. The prosecution of Anton Mussert, NSB leader, culminated in a judgment delivered in The Hague on December 12, 1945, with the sentence executed on May 7, 1946. Special courts treated membership in German-controlled units, participation in political policing, and material support to occupation authorities as qualifying offenses when accompanied by documentary proof, payroll entries, unit orders, signed editorials, or procurement contracts. Administrative tribunals reviewed teachers, civil servants, and journalists in parallel, allowing reinstatement where files showed limited compliance under compulsion and no discretionary cooperation. Belgium and Denmark opened with similar sequencing. Belgian military courts proceeded first against Rexis cadres and members of collaborationist police formations, where accused persons had fled trials in absentia, preserved the record for future enforcement. Professional commissions in the press and broadcasting sectors examined wartime editorial lines and specific directives received from German propaganda Abteilung offices. Denmark, using emergency legislation, carried over from 1940 and refined by the Danish Council in exile, brought cases before Byret and Landsret benches for political collaboration and armed service under enemy command. A separate track reviewed civil service appointments made during occupation. In both countries, prosecutors preferred cases with multiple redundant sources, unit lists, municipal registry entries, and seized correspondence to minimize reliance on single witness testimony. In Germany and Austria, Allied-directed administrative screening produced the earliest mass decisions. In the American zone, Fragebogen collection expanded through the second half of 1945, and Sprüchkammern panels began issuing provisional classifications in early 1946, applying 5 categories, ranging from major offender to exonerated, with sanctions scaled to responsibility and evidence. Bavaria and Hesse prioritized police, education, and industry management cadres. Württemberg-Baden focused early on municipal administrations and utilities to stabilize water, power, and tram networks. The British zone emphasized professional self-policing. Teachers and lawyers' chambers conducted first-instance reviews subject to appeal to regional advisory boards, while the French zone linked denazification to property and industrial policy in the Saar and Rhineland. In Austria, federal measures adopted by the provisional government under occupation oversight combined removal from office with procedures for reappointment after documented review. The Soviet zone of Germany implemented removals through provincial administrations under Soviet military administration oversight. Early orders targeted former party and security functionaries, school principals, and press editors. Replacements were drawn from anti-fascist committees and newly formed parties, with local personnel files reviewed by mixed commissions, including police and party representatives. Similar methods appeared in Poland, Czechoslovakia, and Yugoslavia. Extraordinary courts tried specified wartime offenses, while commissions verified citizenship status, screened police and rail personnel, and reassigned those cleared to priority sectors. In Czechoslovakia, extraordinary people's courts opened in 1945 with cases against collaborators and functionaries. the trial of Karl Hermann Frank in Prague in 1946, while focused on occupation policy and war crimes, intersected with domestic retribution by establishing documentary links among police orders, unit deployments, and administrative cooperation. Repatriation streams became an evidentiary source. Displaced persons camps in the western zones compiled identity cards with unit fields and service dates. Liaison officers forwarded suspect names to national authorities. In the East, NKVD filtration points interviewed returnees, compared statements to captured unit rosters, and flagged service in Schutzmannschaft and Hilfspolizei, or occupation administrations. Individuals cleared for release received assignments to labor-short industrial and transport nodes. Those held for further inquiry were routed to regional investigators with instructions to check residence histories and municipal registries. These channels generated early arrests based on unit identification rather than on community denunciation alone. The first engagements exposed the friction points built into the systems. Courts and commissions faced contradictory affidavits where occupation-era denunciations reappeared as evidence. Panels developed practices to test reliability by cross-referencing dates, locations, and the presence of named units. Economic cases demanded audits to distinguish ordinary deliveries under requisition from discretionary contracts that materially supported the enemy's military effort. In the press sector, investigators separated routine publication of occupation orders, required by law in most territories, from editorial advocacy, using signed pieces and documented instructions from propaganda offices as differentiators. In schools and universities, committees examined admissions decisions and ceremonial participation, alongside documented collaboration in security functions. Public order considerations shaped the pace and scope of early actions. Ministries authorized provisional reinstatement when suspensions threatened essential services, subject to periodic review and the obligation to appear when summoned. Police and gendarmerie prioritized the seizure of archives and arrest of document custodians to prevent loss of evidence. Border districts received additional personnel during the first months to control flight and to coordinate with Allied patrols. Courts scheduled high-visibility trials in capital cities to centralize security and to ensure access to national archives. Provincial panels handled the bulk of files in smaller venues to minimize transport and detention bottlenecks. By mid-1946 in most jurisdictions, the first wave had generated the initial profile of outcomes. Senior political and security figures adjudicated in central courts. Mid-level administrators and professionals screened by commissions with graded sanctions. Rank-and-file cases batched for summary review, where files showed limited, compelled compliance. The next phase would expand throughput and standardize classifications, introducing appeals, property measures, and rehabilitation procedures, while refining how evidence rules addressed contested testimony, economic collaboration, and the boundary between survival under occupation and punishable cooperation. Caseloads expanded faster than institutions could absorb them, and by early 1946, the purge machinery in most countries entered a phase of strain. Intake centers reported rising backlogs as questionnaires, denunciations, and captured files converged on the same registries. Prison and internment capacity set hard ceilings. Prosecutors prioritized detainees nearing statutory custody limits, while police released low-risk suspects on reporting bonds to keep cells for high-responsibility cases. Courts adjusted calendars by grouping similar files, press, auxiliary police, municipal administration, into batches to standardize evidentiary rulings. Commissions issued circulars clarifying that unsigned accusations would be set aside and that documentary corroboration, dated payrolls, unit rosters, requisition orders, would carry greater weight than uncorroborated testimony. Throughput rose, but so did appeals. In France, Cour de Justice decisions generated a predictable stream of petitions to the Court of Cassation. Chambres civiques, rulings on loss of civic rights, triggered administrative appeals that required new staff in interior ministries. The Netherlands special courts coordinated with administrative tribunals to prevent contradictory outcomes, criminal conviction in one venue and reinstatement in another, by sharing file indexes and abstracting key facts. Norway's settlement faced a resource pinch in district courts. To maintain uniformity, the Supreme Court issued reasoned opinions on disputed legal points such as the application of treason articles to administrative service, which lower courts cited to harmonize sentencing. Economic reconstruction pressures produced crises in specific sectors. Railways needed experienced dispatchers and locomotive engineers. Power stations required foremen familiar with aging turbines. Ports depended on stevedore bosses able to rebuild labor rotations. Ministries authorized provisional reinstatements for personnel whose files showed no security functions and whose skills were in short supply, with periodic reviews and the possibility of later sanctions. In Germany, the American, British, and French zones differed in emphasis, professional self-policing versus centralized boards, but all used temporary clearances in utilities and transport to prevent interruptions in coal shipments and winter heating. In Austria, federal authorities under occupation oversight issued reinstatement guidelines for municipal services, while reserving final classification to denazification panels. Evidence problems intensified as investigators reached beyond capital cities. In rural districts, occupation-era archives were incomplete or dispersed. Commissions relied on municipal rolls, ration ledgers, and school registers to reconstruct service histories. Where captured German records were intact, payrolls for auxiliary police or requisition ledgers for factories, audits distinguished deliveries under legal requisition from discretionary contracts negotiated for profit. Press cases were screened by separating mandatory publication of occupation orders from editorial advocacy. Signed articles and correspondence with propaganda offices served as differentiators. In education, committees examined admissions and appointments, looking for patterns that aligned with security objectives rather than isolated ceremonial appearances. The legal threshold for violence-related allegations remained a focal point. Panels differentiated between command responsibility, issuance of orders, supervision of units, and individual participation in unlawful arrests or killings, requiring a chain of documents or multiple witness statements, placing an accused at a specific time and place. In Eastern Europe, extraordinary courts addressed wartime offenses with statutes that tied liability to service in specified formations. Parallel administrative bodies screened police, transport, and local administrations for security risk. The presence of Soviet liaison officers and the priorities of newly dominant parties shaped classification. Anti-fascist credentials and post-war political alignment could mitigate sanctions for individuals with ambiguous wartime records, while service in certain security auxiliaries triggered automatic review. International factors sharpened choices. Allied Control Council directives in Germany established common categories across Western zones, but the onset of political divergence in 1946 complicated joint administration of document centers and property seizures. Information exchanges continued for high-profile suspects and industrial assets. Yet differing labor and industrial policies produced unequal reintegration rates for mid-level managers and technical staff. National governments balanced domestic expectations for accountability against the need to secure Allied support for financial stabilization and raw material allocations. Ministries reported that bottlenecks in coal and transport threatened food distribution if screenings sidelined too many experienced supervisors at once. Social tensions accompanied legal escalation. Veterans groups and resistance networks pressed for visible progress in trials of high-ranking figures, and in cases involving denunciations that had led to deportations. Governments responded by scheduling prominent trials in accessible venues, and by publishing digest summaries of decisions, including acquittals and reinstatements, to reinforce that outcomes varied with evidence and responsibility. To prevent renewed vigilantism, police issued instructions against unauthorized arrests and property seizures, and prosecutors opened files on assaults linked to private grievances disguised as post-war justice. Public communication emphasized the right to appeal and the possibility of rehabilitation after defined periods, aiming to lower the temperature without signaling impunity. Casualty figures of administrative conflict were institutional rather than military. backlogs measured in files rather than in losses, and reinforcements arrived as law clerks, auditors, and translators. Yet the stakes were high. In ports and industrial basins, a stalled purge could paralyze coal transport or power output. An overbroad purge could do the same by draining skilled labor. Authorities used metrics, average processing time, proportion of reinstatements in essential services, rate of appeal reversals, to recalibrate. Where appeal bodies overturned a high share of decisions for lack of corroboration, first instance panels tightened their reliance on documents. Where reinstatement rates were high but subsequent investigations identified new evidence, ministries refined provisional clearance criteria and imposed mandatory rechecks after set intervals. International relief and migration created further complexity. Displaced persons camps in the western zones and NKVD filtration in the east continued to feed names and files into national systems. Liaison officers reconciled conflicting identifications of the same person, civilian worker, auxiliary policeman, or conscript, in different repositories. Border districts adjusted patrols as some suspects attempted to cross into neighboring jurisdictions. Ministries negotiated extraditions for specified offenses while declining requests that lacked documentary bases. These cross-border exchanges confirmed that the purge was not purely national. It existed within a wider post-war order in which transport links, population movements, and Allied coordination could either support or strain legal systems. By late 1946, the crisis phase had clarified three operational constraints. First, the volume of cases required categorization schemes that conserved attention for files with serious allegations or command responsibility. Second, economic recovery set outer limits on personnel removals in utilities, transport, and healthcare, making provisional reinstatement and staged review structural, not exceptional. Third, political consolidation influenced evidentiary weighting and rehabilitation policies, as governments defined who could be trusted to rebuild institutions. With these constraints identified, authorities prepared to scale classifications and to formalize property measures, civic disabilities, and paths to appeal and rehabilitation. The next stage would reach peak intensity, as the largest cohorts, teachers, police, municipal staff, industrial managers, received standardized rulings that converted individual files into a statistical profile of post-war accountability. Peak intensity arrived in 1946 to 1947, when classification systems ran at full scale and governments synchronized courts, commissions, and labor offices. In the western zones of Germany, document centers and Sprüchkammern worked from standardized templates to convert questionnaire data into rulings at district level, then aggregated results for appeals at land level. The five-category rubric: major offender, offender, lesser offender, follower, exonerated, allowed panels to map sanctions onto responsibility while preserving exceptions for essential technical staff. In parallel, British and French zone authorities tightened professional self-policing. Teachers' chambers staged mass sittings to clear or suspend entire cohorts before school terms began. Bar associations rechecked members against seized party lists, and industrial advisory boards reviewed plant directors with auditors present to separate managerial continuity from political activity. Austria followed a similar rhythm under occupation oversight, using federal statutes to remove and to reappoint with recorded justifications, creating a paper trail that could be revisited on appeal. Legal peaks elsewhere followed national calendars. In France, Cour de Justice and Chambres civiques shifted from ad hoc sequencing to sector blocks. Press and broadcasting in one tranche, police and intelligence in another, then municipal administrations and education. Courts issued reasoned judgments identifying the evidentiary standard for treason versus professional misconduct, and administrative bodies published scales for loss of civic rights tied to functions held under occupation. The Netherlands' Bijzondere Gerechtshoven moved large numbers of rank-and-file files via summary procedures when documentary evidence showed only membership without command or security duties, reserving full trials for organizers, political police, and economic cases with substantial military relevance. Norway completed the main run of treason cases, while appellate rulings standardized how administrative service under occupation interacted with criminal liability. Belgium and Denmark brought press, police, and local administration cases into predictable cycles, allowing ministries to plan school staffing and municipal budgets around known suspension and reinstatement windows. In Central and Eastern Europe, peak operations combined retribution with state reorganization. Polish special criminal courts concluded major prosecutions linked to specified formations, while verification commissions expanded in territories transferred from Germany, matching citizenship reviews with screenings for police, rail, and municipal posts. Czechoslovakia. Extraordinary people's courts reached high visibility judgments, while parallel commissions processed professional registers. Reorganization of citizenship and property regimes proceeded through administrative decisions that referenced wartime conduct alongside current loyalties. In Yugoslavia, people's courts concluded cases linked to wartime killings and forced labor, while state-building measures replaced wartime partisan structures with ministries and permanent police commands. Throughout the region, liaison with Soviet advisors maintained emphasis on security reliability and control of transport, communications, and heavy industry. Property and professional measures reached their widest application at this stage. Authorities implemented sequestration or fines where courts found unlawful enrichment through occupation contracts or unlawful transfers of assets. In the press sector, commissions examined ownership changes under occupation and adjusted licenses accordingly. Universities ran broad habilitation reviews that combined wartime behavior with post-war performance, resulting in dismissals, probation, or reinstatement with conditions. Medical and legal professions adopted probationary supervision for reinstated members whose files contained minor political infractions but no security functions. For large plants tied to coal and power networks, boards issued conditional reinstatements paired with external audits and periodic file checks, a compromise designed to keep output steady while maintaining leverage pending appeals. Throughput management relied on triage and feedback. Intake centers batched files by evidence type. Documentary cases with payrolls, orders, or signed editorials went to fast-track panels. Testimony-only cases queued for investigators to seek corroboration. Metrics were published internally: average days to first decision, ratio of reinstatements to bans, appeal reversal rates, so ministries could adjust resources. Where reversal rates rose, first instance panels revised guidance to require more than one independent source for allegations of violence or denunciation. Where essential services faced shortages, ministries authorized temporary clearances with scheduled rechecks and duty reassignment away from sensitive posts. Labor offices mapped reinstated personnel to bottleneck sectors, rail dispatch, power stations, municipal water, so that legal outcomes translated immediately into operational staffing. International and interzonal coordination intensified. In Germany, Allied Control Council bodies continued to exchange information on high-responsibility suspects and industrial assets even as political divergence grew. Document centers cross-checked names appearing in multiple zones, ensuring that a ban in one did not become a loophole in another. Western displaced persons camps and Eastern filtration points supplied unit lists and service histories that commissions incorporated into domestic files. Extradition requests moved through Allied channels with requirements for documentary support and specified offenses. Border police coordinated transfers to keep courts supplied with defendants while minimizing detention overflows. War crimes proceedings, international and national, fed records into domestic cases, linking unit deployments and police orders to individual files without collapsing distinct legal categories. Public order and communication measures were calibrated for the peak. Governments scheduled prominent trials in venues with reliable security and made space for accredited observers, while district panels handled volume quietly to avoid congestion. Ministries issued bulletins summarizing decision types by sector, numbers reinstated, suspended, or banned, so communities understood that outcomes varied. Police and prosecutors discouraged punitive demonstrations outside courthouses and directed victims and witnesses to formal deposition centers with fixed hours and standardized forms. Radio and press carried practical guidance on appeals deadlines, document repositories, and the difference between criminal courts and administrative commissions, emphasizing that provisional reinstatement did not preclude later sanctions if new evidence emerged. Civilian life absorbed the administrative shock. Households encountered the purge at workplaces, schools, ration offices, and transport hubs. Teachers changed midterm. Tram routes resumed after drivers received temporary clearances. Hospitals reorganized shifts when senior nurses returned under probation. Municipalities managed payroll continuity by appointing acting officials pending final rulings. In industrial regions, unions and works councils participated in oversight committees, providing shop floor testimony about wartime conduct while negotiating protections against indiscriminate dismissals that could halt production. Churches, cultural associations, and professional societies documented wartime, charitable, and relief work to support members seeking reinstatement. Commissions noted such records, but weighed them against any documented participation in security functions. Policy inflection points appeared within the peak. Italy's June 1946 referendum and the late June amnesty introduced early rehabilitation paths, nudging prosecutors to prioritize violence and command, while administrative bodies closed files with civic penalties rather than employment bans where public safety was not implicated. In France and Belgium, stabilization of coalition governments allowed ministries to publish clearer scales for sanctions and to expand rehabilitation for categories classified as passive political affiliation without security service. In Germany's western zones, pressure from economic recovery plans encouraged broader use of fines and probation in place of extended professional bans for technical staff, while the Soviet zone integrated screenings with party building and land reform, linking rehabilitation to participation in new political and administrative structures. By the end of the peak phase, the systems had produced a statistical profile of accountability that could be measured in classifications, sanctions, and reinstatements. High command figures and leaders of specified formations had been tried or were in custody awaiting judgment. Mid-level administrators and professionals had received graded outcomes tied to function and evidence. Large cohorts with minor or uncorroborated allegations moved through summary review with warnings or civic disabilities. The next stage would pivot from expansion to consolidation. Appeals and revisions, property settlements, codified rehabilitation pathways, and the gradual integration of purge institutions into a normalized legal order in which memory politics, rather than emergency procedures, would frame how communities and states define the boundaries of acceptable conduct under occupation. Adaptation began within the very systems designed to exclude. Appeals bodies matured into predictable venues with calendars, form requirements, and jurisprudence that reduced variance between districts. Where early hearings had mixed testimonial and documentary weights unevenly, appellate rulings clarified thresholds. A single witness unsupported by dated documents could sustain administrative caution, but not a criminal sentence. Payroll entries or unit orders with signatures outranked recollections. Ministries issued circulars summarizing these holdings, so first-instance panels could adjust without waiting for case-by-case reversals. Defense strategies adapted in step. Counsel requested copies of seized files, traced chain of custody for occupation-era records, and compiled timelines of postings, ration issuances, and hospital admissions to test whether the accused could have been present at alleged locations. In rural districts where archives were incomplete, attorneys gathered parish registers and school attendance books as auxiliary chronologies. The process did not end dispute. It narrowed what counted as admissible proof. Workers and managers adapted to preserve production while files moved through review. Unions negotiated protocols that separated removal from immediate dismissal. Acting supervisors covered shifts, while suspended staff awaited classification. Safety-critical posts, Boiler operators, mine timbering crews, locomotive engineers required sign-off from technical inspectors before replacement. Employers submitted staffing maps to commissions showing which positions could be filled by newly trained personnel and which required experienced hands under probation. In coal and steel regions, works councils added shop floor statements to personnel files, noting whether the accused had exercised disciplinary authority during occupation or had confined themselves to routine tasks under requisition. These additions did not erase liability. They allowed panels to scale sanctions so that plants, tramways, and hospitals could maintain service. Communities developed codified channels for testimony. Depositions moved from informal letters to standardized forms with fields for dates, named units, and corroborating documents. Churches, charitable associations, and professional societies provided certificates of wartime relief work, sheltering of evacuees, or refusal to join prescribed organizations. Commissions logged these as contextual materials alongside any contrary evidence. Victims' associations organized archives of deportation orders, convoy lists, and police reports to aid prosecutors, reducing reliance on memory alone. Newspapers, which had been early targets of screening, now printed notices detailing where to submit documents and how to retrieve them after cases closed. States introduced rehabilitation pathways as part of adaptation. Italy's June 22, 1946 amnesty opened avenues for sentence reduction and reintegration for specified offenses not involving the most serious violence. Administrative bodies adjusted by closing files with civic disabilities, or fines where criminal liability was extinguished. France and Belgium issued scales that converted lesser political affiliation during occupation into time-limited loss of rights rather than long employment bans, with eligibility for review after fixed periods. In the western zones of Germany, probationary reinstatement paired with fines and mandatory rechecks became common for technical staff, whose records showed membership without command or security functions. In the Soviet zone and in Allied Eastern European states, rehabilitation linked to participation in new political and administrative structures. Completion of political education courses, service in reconstruction brigades, or documented anti-fascist activity could move a file from suspension to conditional reinstatement. International agencies reshaped adaptation by changing who remained within national jurisdictions. UNRRA operations and, from 1947, the International Refugee Organization processed displaced persons for resettlement while screening out individuals identified with specified formations. This diverted some potential defendants from domestic courts by placing them under international procedures and, conversely, returned others when documentation matched names across card indexes. Allied liaison offices established routines for exchanging extracts, service histories, camp records, transport manifests, so that domestic commissions could update files without reopening investigations from the beginning. Extradition became more formalized. Requests required enumerated offenses and copies of documents. Receiving authorities accepted or declined based on statutory compatibility and evidentiary sufficiency. Individuals under review adopted a spectrum of responses that the systems gradually anticipated. Some attempted to relocate between zones or across borders. Border police increased document checks at rail junctions and established joint patrols with Allied units to limit flight. Others pursued name changes or claimed mistaken identity. Commissions countered with cross-reference tables linking occupation-era employment numbers, ration cards, and housing registries. A subset sought to preempt sanctions by providing information on networks or by volunteering for difficult reconstruction tasks. Ministries responded by clarifying that cooperation could affect sanctions only after independent verification. Defense submissions increasingly included expert opinions, engineers attesting to necessity of specific production runs under requisition, archivists analyzing provenance of seized documents. So, panels added technical assessors to hearings when evidence turned on industrial processes rather than on political affiliation. Psychological and social adaptations appeared in schools, factories, and municipal offices Training programs expanded to replace staff removed by sanctions. Accelerated courses produced dispatchers, nurses, and clerks capable of filling essential posts. Universities reopened with provisional curricula that included administrative law and record-keeping, reflecting demand for personnel able to manage case files and appeals. Professional ethics codes were rewritten to address conduct under occupation and expectations under new regimes. Municipalities instituted rotation rules to reduce concentration of decision-making in any one office during screening, limiting the risk that pending cases could stall essential services. Legal doctrine adapted to recurring problem sets. Economic collaboration cases required auditors capable of distinguishing requisition compliance from discretionary enrichment. Ministries hired accountants to examine unit prices, delivery frequencies, and correspondence with occupation procurement offices. Courts clarified when command responsibility attached to department heads who had signed orders under duress, and when liability remained with specific subordinates. Panels standardized the treatment of denunciations. Allegations leading to arrests or deportations required either a signature on a formal statement or multiple independent attestations confirming the accused's role in initiating the process. Where evidence conflicted, panels recorded both versions and proceeded on what could be independently corroborated, leaving moral narratives to later historical debate. By mid-1947, adaptation manifested as policy inflection influenced by external recovery plans. The announcement of European recovery proposals in June 1947 sharpened ministry's emphasis on transport, power, and coal throughput. Screening calendars were aligned with maintenance outages at power plants and with rail timetables to avoid compound disruptions. Labor offices paired reinstatement decisions with targeted placements in bottleneck sectors. Property cases moved from seizure to settlement schedules, where audits found mixed patterns, lawful requisition contracts coexisting with episodes of unlawful enrichment, so that restitution, fines, and continued operations could be combined without dismantling productive capacity. Memory politics also adapted, though its legal effects were indirect. Governments and civic groups began formal commemorations and erected markers at former prisons, execution sites, and deportation departure points. These practices influenced priorities insofar as prosecutors and commissions scheduled cases to coincide with anniversaries or to ensure that archives were available for public exhibits after proceedings concluded. Educational materials drew on redacted case files to teach administrative law, due process, and evidentiary reasoning, embedding lessons from the purge machinery into post-war civic instruction without naming individual defendants outside published judgments. Across jurisdictions, the theme of resistance and adaptation converged on a practical equilibrium. Systems initially designed for removal developed mechanisms for reintegration. Populations that had expected swift, uniform outcomes learned to interpret variation as a function of evidence and role, and institutions that might have stalled under rigid exclusions reorganized to keep services running while cases proceeded. This was not a single policy, but a set of adjustments: appeals jurisprudence, probationary reinstatement, targeted training, audited property settlements, and calibrated extradition that allowed the vetting apparatus to operate at scale without severing the logistical ties on which recovery depended. The stage was set for a turning point shaped less by procedural invention than by the broader political realignments of 1947, when coalition structures, emerging international aid, and intensifying ideological competition began to redefine what counted as closure and what remained open in the legal and administrative aftermath of occupation. The turning point arrived in 1947, when legal design and peak throughput met a new political landscape that reweighted priorities. In Germany, economic and administrative consolidation began with the creation of the buy zone on January 1, 1947, linking the American and British zones and aligning denazification calendars with coal and transport recovery programs. Policy guidance shifted as occupation directives that had emphasized removal were revised toward reconstruction. Classification boards were instructed to prioritize cases with command responsibility and documentary corroboration, and to channel lesser files toward fines, probation, or warnings tied to employment in essential services. Appeals bodies received authority to convert open-ended professional bans into fixed-term disabilities with review dates, allowing ministries to plan staffing quarters in advance. The same month-by-month shift appeared in Austria, where occupation authorities and federal ministries synchronized reinstatement windows with winter power and heating schedules, reserving full hearings for security services and high-responsibility managers. International commitments reframed domestic objectives. The Truman Doctrine announced on March 12, 1947, made security reliability a declared criterion within Allied planning, and the European Recovery Proposal announced on June 5, 1947, tied aid to the rapid restoration of production and transport. Ministries translated these signals into administrative rules. Rail dispatchers, mine supervisors, and power station foremen could be reinstated under probation if files showed membership without security duties, and if documentary checks found no signed orders linking them to unlawful arrests or violence. Where files contained mixed evidence, party dues alongside exculpatory shop floor statements, or wartime medical records, appeal panels adopted scales that balanced fines and civic disabilities with conditional return to work. Document centers adjusted workflows accordingly. Cases supported by unit orders, payrolls for specified auxiliary formations, or signed editorials moved to full hearings. Testimony. Only cases were routed to corroboration queues with deadlines, after which provisional classifications would stand unless new documents appeared. Eastern and Central Europe registered the same pivot through different mechanisms. In Poland, the January 1947 election and subsequent amnesty for underground participants altered prosecutorial calendars. Extraordinary courts concentrated on cases built on captured German documentation and specified formations, while verification commissions in the newly incorporated Western territories accelerated screenings tied to citizenship and municipal employment. Czechoslovakia's extraordinary people's courts concluded high-visibility prosecutions, and attention shifted to administrative decisions on citizenship and property, where wartime conduct formed one factor among several. Ministries published instructions defining when wartime service in occupation era local offices barred or permitted post-war municipal posts. In Yugoslavia, people's courts completed major wartime violence cases, and ministries formalized the transition from partisan organs to permanent administrative structures. Rehabilitation was linked to documented anti-fascist work and participation in reconstruction brigades, with security vetting retained for police and transport. Interzonal and international legal processes emphasized record linkage rather than expansion of categories. Subsequent war crimes proceedings continued in 1947 in several jurisdictions, supplying unit diaries, transport manifests, and police circulars that domestic commissions used to test specific allegations. Liaison offices standardized extradition requests with enumerated offenses and copies of documents. Receiving authorities required statutory compatibility and verification of identity across ration cards, residence rolls, and employment numbers. UNRWA's winding down and the handover to the International Refugee Organization shifted displaced person screening onto new forms, but the evidentiary principle remained. Unit designation plus dates and signatures outweighed unaided recollection. As a result, many pending files crystallized either into prosecutable records or into administrative dispositions with time-limited effects. Domestic jurisprudence fixed the evidentiary hierarchy that would govern the remainder of the purge. 1947 issued opinions that lower bodies cited as binding guidance. A single accusation, even if sincere, could justify temporary suspension, but not a criminal conviction, without independent support. Payroll entries alone were insufficient for violence allegations, unless linked to orders or reports placing the accused at a named site on a specific date. Command responsibility attached, where signatures or minutes showed authority over units conducting unlawful arrests, regardless of personal presence. Ministries summarized these holdings in circulars to standardize first-instance decisions, reducing reversal rates and making outcomes more predictable across districts. Amnesties and rehabilitation rules consolidated the shift. Italy's 1946 measure had already redirected many files towards civil penalties. By 1947, ministries completed the conversion of suspended employment bans into fixed terms with appeal milestones. France and Belgium published sectoral scales distinguishing political affiliation from security service, with eligibility for rights restoration after defined periods if no new evidence emerged. In the western zones of Germany, Länder-level legislation created formal routes from follower status to reinstatement, with fines and probationary oversight, while maintaining stronger sanctions for activists and office holders documented as issuing orders or managing security operations. In the Soviet zone and aligned states, rehabilitation pathways were tied to political integration, completion of courses, verified participation in reconstruction, and service in new local organs could move a case from suspension to conditional clearance, whereas files showing service in specified auxiliary police remained subject to heightened review. Administration absorbed these legal changes into logistics. Labor offices mapped clearance decisions to bottleneck posts in coal fields, marshalling yards, and municipal utilities. Training programs filled gaps left by permanent bans. Accelerated courses produced dispatchers, nurses, and clerks able to assume duties where reinstatement was not authorized. Auditors completed property cases by distinguishing lawful requisition performance from unlawful enrichment. Where both appeared, settlements combined fines, restitution, and continued operation under oversight rather than indefinite sequestration. Municipalities implemented rotation policies for sensitive posts to avoid concentration of authority, while pending appeals moved through calendars fixed by quarter. Memory politics diverged visibly in 1947. Western governments emphasized plural commemorations of resistance while publishing statistics that included acquittals, reinstatements, and reduced penalties to signal procedural regularity. In the Soviet zone in Eastern Europe, official narratives foregrounded anti-fascism and class alignment. Screenings increasingly weighed post-war political participation alongside wartime records. The term collaborator thus hardened into different administrative labels. In the West, category codes linked to sanctions and appeal rights. In the East, security classifications tied to party-state staffing and citizenship decisions. The divergence did not erase shared methods, use of signed documents, unit logs, and registries, but it changed the consequences that followed the same evidentiary thresholds. By the close of 1947, the shift was measurable in calendars and dispositions rather than in a single decree. Criminal prosecutions focused on documented leadership, command responsibility, and specified formations. Administrative systems converted many open-ended suspensions into finite sanctions with rehabilitation routes. International liaison narrowed rather than broadened the universe of cases by insisting on documentary support across repositories. What began in 1945 as a broad promise of purification had become, by 1947, a managed legal technical regime embedded in reconstruction timetables and political consolidation. The next phase would trace how this consolidation concluded the bulk of proceedings, how property and civil status measures were settled, and how schools, courts, factories, and municipalities emerged from emergency procedure into normalized law, while the politics of remembrance stabilized into durable public narratives that assigned meaning and limits to the label applied in the immediate aftermath of occupation. Withdrawal from emergency procedure did not occur as a single decree, but as a sequence of administrative endings that unfolded sector by sector between late 1946 and 1948, with 1947 marking the pivot from expansion to closure. Courts finished the largest, best-documented files, leadership of political movements under occupation, command responsibility in police and auxiliary units, and economic cases tied to military supply, while commissions converted open suspensions into fixed-term disabilities, fines, or reinstatements under probation. Ministries issued circulars instructing that pending low-risk cases without documentary corroboration be archived with a notation of no further action unless new evidence, a phrasing that allowed reopening while freeing capacity for appeals and property audits. Municipalities replaced emergency acting officials with permanent appointees selected under ordinary civil service rules, signaling a return to routine governance even as some positions retained periodic recheck requirements. Retreat from mass internment followed similar logic. Detention lists drawn up in 1945 to 1946 were re-audited against evidentiary hierarchies adopted in 1947, signed orders, payrolls of specified formations, unit diaries, and dated correspondence remained decisive. Single witness accusations without corroboration did not sustain continued custody. Release programs prioritized detainees cleared for essential services or lacking documentary ties to security functions, pairing discharge with reporting obligations and residence registration. Where prisons and camps held mixed populations, political leaders alongside rank-and-file employees, authorities separated files to avoid blanket outcomes. International liaison thinned, not widened. The stream of new arrests, extradition requests that arrived without enumerated offenses or documentary attachments were returned for supplementation rather than executed on summary assertions. Humanitarian consequences were immediate and measurable in municipal offices rather than in public squares. Reinstated staff returned to work under probationary schedules that balanced payrolls and oversight. Households regained access to ration books and housing registers when heads of family were cleared or when spouses received authorization to manage accounts. Pension funds and professional associations adjudicated eligibility in light of administrative classifications. Loss of civic rights did not necessarily entail loss of contributory benefits, but files involving documented security service triggered separate reviews. Schools normalized calendars after 2 years of midterm substitutions, while universities reabsorbed students and instructors whose cases had closed with civil penalties. Hospitals reorganized shifts as suspended nurses and physicians returned under supervision. And health ministries reopened specialist clinics that had closed during peak screenings. Property dispositions shifted from emergency seizure to settlement. Audits distinguished lawful deliveries under requisition from unlawful enrichment. Mixed cases produced composite outcomes, restitution of specific assets, fines assessed on the unlawful margin, and continued operation under monitoring. In rural districts, land reform and citizenship verification intersected with property claims. Commissions tied decisions to wartime conduct only when files contained documentary links between local office holders and unlawful coercion. Otherwise, post-war economic policy, not retribution, determined allocation. Urban housing authorities regularized occupancy where wartime transfers had been voided, granting leases to current residents when owners were missing or deceased, and setting aside a portion of units for families of deported or executed persons identified in the court records. Population movement marked the social edge of withdrawal. Displaced persons left assembly centers for repatriation or third country resettlement, screened by criteria codified in 1947 that excluded individuals documented as serving in specified formations. Border districts adjusted patrols from roundups to verification, checking names against centralized card indexes rather than generating new suspect lists. In territories that experienced post-war transfers of sovereignty, citizenship decisions and municipal employment screenings concluded in staged waves, allowing registries and payroll offices to stabilize. For individuals denied reinstatement or stripped of civil rights, appeal calendars provided defined milestones. Defense counsel calibrated submissions to the evidentiary hierarchy. Documents first, testimony as corroboration, to move files from indefinite suspension to finite dispositions. International trials and national war crimes proceedings continued in parallel, but no longer set the tempo of domestic vetting. Instead, they functioned as archival engines. Unit rosters, transport manifests, and police circulars entered domestic repositories, enabling precise confirmations or exclusions in individual files. Where domestic charges overlapped with crimes under international law, prosecutors deferred to higher jurisdictions and paused administrative sanctions to avoid conflicting outcomes. The vast majority of cases, however, resolved within national frameworks as administrative law, absorbed questions that criminal law had neither the capacity nor the mandate to adjudicate at scale. Civil society adapted to closure by formalizing memory without converting it into evidence. Commemorations at former prisons, execution sites, and deportation departure points established calendars that ministries respected when scheduling file transfers to archives. Museums and schools presented anonymized case studies illustrating evidentiary standards, how a payroll entry, a unit order, and a dated report could align to establish command responsibility. Without naming individuals beyond published judgments, victims' associations maintained archives to support late-discovered claims, while government bulletins published aggregate statistics by sector, numbers reinstated, suspended, fined, or banned, to demonstrate regularity and to reduce pressure for new waves of accusations. Economic indicators framed the endgame. Coal shipments, rail punctuality, power plant availability, and hospital bed capacity served as guardrails. Screening calendars were synchronized with maintenance outages and school terms to minimize cumulative disruption. Labor offices aligned reinstatement with bottlenecks, assigning cleared locomotive engineers to marshalling yards, electricians to urban substations, and senior nurses to emergency wards. Where permanent bans created gaps, accelerated training programs supplied replacements. Certificates from these programs appeared in personnel files to document competency alongside legal status. Ministries tracked appeal reversal rates to calibrate first-instance panels. Declining reversals signaled that guidance issued in 1947 had stabilized evidentiary practice. Not all withdrawals proceeded smoothly. In districts where archives had been destroyed or removed, unresolved files lingered. Authorities closed them provisionally with notations inviting resubmission upon presentation of new documents. In some municipalities, appointments made under emergency rules persisted longer than anticipated because competitive examinations could not be organized until appeal waves subsided. Political realignments influenced pacing, where coalition governments stabilized. Ministries issued final scales, converting residual suspensions into civic disabilities. Where competition intensified, screenings of police and press staff continued longer, with closer liaison to security services. Yet, even in these variations, the procedural direction held. From open-ended uncertainty toward finite classifications with named consequences and appeal routes. For individuals labeled Collaborator, the immediate aftermath combined clarity and constraint. A person could read their file, see the documents that supported the classification, and know the term of any disability, the amount of any fine, the conditions of probation, and the earliest date for review. For institutions, the aftermath meant staffing maps that balanced expertise and oversight, audit schedules that matched production cycles, and reporting routines that fed lessons back into administrative law. For communities, it meant that the language of accusation moved from rumor to form, from testimonial to document, and from indefinite exclusion to calibrated sanction. With emergency machinery winding down, the contours of a normalized order emerged, one in which legal closure did not erase memory, but placed it within archives, ceremonies, and curricula, while daily life resumed under rules that sought to separate the fact of survival under occupation from the punishable acts that post-war states had chosen by documented standard to define. Legacy took shape in institutions, archives, and law, rather than in a single verdict. By the end of 1947, the purge systems had produced records that define how states remembered the occupation years and how they governed trust afterward. Personnel files carried standardized fields, membership, functions held, dates, unit designations, sanctions, appeal outcomes, so that later administrations could read a person's wartime and post-war trajectory in one dossier. Ministries codified what had begun as emergency practice, evidentiary hierarchies privileging signed orders and dated payrolls over unaided recollection, graded categories separating command responsibility from rank-and-file presence, and rehabilitation rules that converted open-ended exclusions into time-limited disabilities with review points. These technical legacies outlasted the tribunals that created them. Constitutional frameworks incorporated lessons from 1945 to 1947. In Germany's western zones, denazification files interacted with the Basic Law, adopted in 1949, by setting expectations for proportional sanctions, due process, and the right to appeal administrative decisions. The Soviet zone, reorganized as the German Democratic Republic in 1949, integrated security screenings into party-state staffing and internal vetting rules that linked loyalty to career paths in administration, rail, and heavy industry. Austria's post-war coalition governance absorbed federal removal and reinstatement statutes into routine civil service law. Elsewhere, France, the Netherlands, Belgium, Denmark, and Norway folded special jurisdictions back into ordinary courts, leaving behind published opinions that lower benches cited when judging later cases involving political conduct in states of emergency. In Poland, Czechoslovakia, and Yugoslavia, extraordinary courts closed as party-state legal orders consolidated, with verification and citizenship decisions continuing through administrative channels that drew on wartime and post-war records. Internationally, documentation generated by national purges and war crimes trials fed into shared legal language. The principles articulated at international tribunals, individual responsibility for orders, the distinction between political affiliation and participation in crimes, evidentiary standards for command, migrated into domestic judgments and law school curricula. Ministries exchanged certified extracts through liaison offices even after occupation structures changed, maintaining cross-border recognition of unit designations and identity numbers. The methodological emphasis on signed, dated documents over general accusation influenced later human rights investigations and transitional justice programs outside Europe, where archivists and prosecutors adopted similar hierarchies of proof. The label Collaborator calcified into administrative codes whose meaning diverged across political systems. In Western Europe, it denoted a classification tied to enumerated sanctions and explicit appeal rights. A person could point to a page and see category, term, and conditions for review. In the Soviet zone and Allied states, it became a security category within personnel management, linked to political education, party membership, and appointment patterns. The same documentary evidence, unit rosters, police circulars, requisition ledgers, could lead either to exclusion or to conditional integration, depending on how post-war political participation was weighted. These differences shaped labor markets and career ladders through the early 1950s, especially in rail, power, police, and education, where vetting had been most intensive. Economic reconstruction fixed outer limits on how the legacy functioned in practice. Coal programs, power plant outage schedules, and rail timetables were built with knowledge of when probationary reinstatements would mature into full clearances or lapse into bans. Training institutions that expanded to replace purged staff, dispatcher schools, nursing colleges, technical academies, remained larger than their pre-war counterparts, creating a generational cohort whose professional identity included instruction in administrative law and documentation standards. Works councils and professional chambers retained oversight committees first formed during screenings. Their minutes became a continuing source for historians studying how factories and hospitals balance continuity with sanction. Property law absorbed the purge into audit routines. Post-war settlements that distinguished requisition compliance from unlawful enrichment created templates for later restitution regimes, specifying how to price wartime deliveries, how to handle mixed patterns of conduct, and how to pair fines with continued operation under supervision. Urban housing authorities kept registers opened during the purge to track voided wartime transfers and post-war regularizations. Those registers later supported social housing policies and claims by families of deported or executed persons, whose names appeared in court records and convoy lists. Rural land commissions used wartime conduct as one factor among several: citizenship, agricultural capacity, post-war investment, establishing multi-criteria decision forms that persisted in administrative practice. Memory politics stabilized into calendars and spaces rather than into new legal categories. Sites of arrest, deportation, and execution became places of commemoration. Ministries coordinated file transfers to archives so exhibits could display facsimiles of signed orders, payroll entries, and unit logs. School curricula presented anonymized case studies that taught students how administrative evidence was assembled and weighed. Veterans and victims associations maintained private archives keyed to official catalog numbers, enabling later research while reducing pressure for renewed proceedings. Public statistics, numbers reinstated, suspended, banned, or fined by sector, entered almanacs and government yearbooks, fixing a quantitative outline of the purge in official memory. Comparative figures highlighted how design shaped outcomes. Systems that emphasized individual acts documented with signed, dated records produced small proportions of severe sanctions, and larger cohorts passing through civil disabilities and probation. Systems that linked screening to party-state building generated more durable employment effects, with long-term consequences for staffing patterns in police, education, and state industry. Yet, across jurisdictions, the evidentiary core converged. Dates, signatures, unit identifiers, and chain of custody notes. The convergence mattered beyond 1947, because later disputes over pension eligibility, professional licenses, or rehabilitation certificates were resolved by returning to those original documents and the classifications derived from them. The long tail of the purge appeared in appellate calendars and personnel reviews into the early 1950s. Cases reopened when new archives surfaced, transport manifests, unit diaries, or municipal registers previously stored in Allied depots or returned from foreign capitals. Rehabilitation petitions increased as statutory waiting periods expired. Ministries applied fixed scales published during 1947 to convert disabilities into restored rights unless new evidence intervened. Where political systems realigned, the same files were read through different lenses, but the administrative form endured: classification codes, reference numbers, and the sequence of intake, decision, appeal, and closure. Historical significance lies in the way these mechanisms turned the fluid moral language of occupation into administrative procedure. They did not erase disagreement about the past. They created pathways for states to act on it. The label at the core of this story, Collaborator, became actionable only when linked to documents that placed a person in a specific role at a named time. That linkage yielded sanctions scaled to function, preserved routes for return to work, and set outer limits where economic recovery required scarce skills. It also produced archives that continue to structure scholarship and public debate. The post-war purges of 1945 to 1947 thus left a double inheritance: a body of rules for handling contested conduct under extraordinary conditions, and a record that allows later generations to compare intentions, decisions, and outcomes across jurisdictions without collapsing differences in law politics or economy into a single narrative.